Ladies and gentlemen, welcome to the Safety and Risk Success podcast. I'm your host, Christian Harris, and I'm joined today by Greg Woods of CMS in the final of our September mini series of podcast episodes. CMS is a law firm, and Greg's specialism is all around personal injury claims defence. So as he'll tell us, he's worked in this field for a number of years, for insurers, for companies directly, built up a huge raft of experience. And we talk about two principal things today. The first is around slip, trip, fall, accidents and claims, and where people are strongest, where people are weakest, how to go about trying to defend these claims, and some of the common misperceptions or common thoughts that people have, and whether those are indeed helpful or not. And then we move on and talk a bit about COVID and some of the potential for liability claims that has arisen from the pandemic, including working from home risks. What's the risk of actually, conversely to working from home, sending everyone back into the office, long COVID, and a few things as well. Greg's got a webinar coming up on that topic, so that's why we thought we would touch on that. As always, hope you enjoy this episode. If you do, please do follow or subscribe. Please give us a review, because that's really, really appreciated, and help to share the word among anybody that has an interest, like I'm sure you do, and I certainly do, in being proactive around safety and risk. Let's get into it then with Greg Woods of CMS. Hi, Greg, and welcome to the podcast.
Hello, great to be here.
It's good of you to spare some time, and we're going to be discussing a couple of really interesting and topical issues. So looking forward to this.
Absolutely, look forward to it.
Good. Would you like to start by just giving a bit of background on you personally, and then the business as well, so people have got that kind of context before we start sort of delving into the main topics?
Sure. So I'm a partner with a law firm called CMS. I specialise in defendant personal injury litigation. It's something I've done for almost 30 years now, acting for insurance companies, large corporate self-insureds, in the defence of personal injury claims, be that disease claims or trauma claims. So the whole range, really. That's my bag. Okay,
and you've recently joined CMS.
I have, yes, joined CMS in May. The CMS is an interesting firm for me to join. It's a huge global law firm. I think it's about the 6th biggest in the world. Offices all over the world and across the country. Mm-hmm. And within that corporate law firm, there's a large insurance practice. And my bit, the personal injury team, is quite a large team within that insurance practice. So I'm getting to understand the firm, the players, what it does, and it's been very enjoyable so far.
Good. And do you have any particular sectors that you either kind of have done a lot of work in and specialise in, or maybe particularly sort of enjoy working in for whatever reason?
Yeah, when I think back, I suppose I've spent different periods of time focused on different areas. So a long time sort of food production, manufacturing, facilities management has been a big part of my life, I guess, working with service providers who are operating in third-party premises, which raises all kinds of interesting challenges in terms of investigation of incidents and defending claims. Often those service partners don't get to hear about an incident until much later, but are expected to sort of pay, indemnify, deal with the claim. So some interesting challenges there. And thinking about CMS, they have particular sector groups which bring together lawyers to focus on business sectors rather than sticking to their defined legal areas. One of the sector groups is hotel and leisure, and I've found over the years I have acted in that sort of context as well quite a bit. So enjoying getting to know the lawyers that work in that particular sector and think about how we can work together to provide clients with an all-embracing service that deals with all areas of risk management, all their legal needs in one home.
Great. Well, that's useful to paint that picture and give the background to people, I think. So thanks for sharing that. So we had a bit of a chat, and we thought there would be two kind of good areas to focus on. One, obviously, given my push at the moment on September will be around sort of slips, trips and falls. So, we'll perhaps start there and then go into the very topical discussion of kind of COVID, and think about some of the stuff around long COVID, and also working from home risks if we're moving to this kind of hybrid. Is that the right word, hybrid?
That's the word that's been bandied around, isn't it?
Yeah. I'm sure there'll be a different word in another month. We'll keep figuring out the way forward. So so that's what we're going to touch upon. So let's start with slips and trips then, because obviously it's a big area of claim historically, and I'm sure will continue to be so in the future. What would you say people can do to sort of be in the best position to kind of think about defending these types of claims?
I think if you ask a lawyer that question, they will always start with, what does the law say? What does the law say your duties are? Your duties as an occupier of premises, or your duties as an employer. And occupiers, people who have control over premises, have a duty to those who visit those premises, a legal duty, to take reasonable care, that they are reasonably safe premises. The duty on employers is similar. Employers owe a duty of care to their employees and those who are affected by what they do. So a reasonable duty of care is owed in law to visitors to premises and employees working in premises. Employers have, in addition, a specific statutory duty in relation to flooring under the Workplace Health, Safety and Welfare Regulations. So Regulation 12 requires employers to ensure that the flooring, the walkways are suitable for the conditions and in a good state of repair, free from defect. And Regulation 12 also requires them to have in place a suitable system for keeping the floors free from substances that might cause someone to slip or trip. So a reasonable system has to be in place to ensure that they address slipping hazards and tripping hazards on walkways. So those are sort of the layers of duty. I think that's where you start.
Yeah.
And then you get on to, well, how do you discharge that duty? Well, what you need to do is to make sure you have a system. You have a system in place, and the starting point, as ever with health and safety, is a risk assessment. Let's think about the risks to people who are visiting our premises. Let's think about the risks to employees, and how do we best control those risks? With slips and trips in mind, you clearly need to have a good system for inspecting premises, inspecting the flooring regularly, a proactive and reactive system for identifying and addressing hazards, both sort of longer term defects that need to be repaired, or transient hazards, spills that may happen on the canteen floor, or whatever it might be. So you need to make sure that you have a reasonable system in place.
Yeah.
You also need to ensure that the people who you engage to carry out the inspections, to carry out the cleaning, are properly trained, that they know how to do the job, and they're provided with the right equipment to do it. So this is the sort of approach one would take as a lawyer. If there has been an incident, think about the system, think about the equipment that was provided, the training that was given, the frequency of the cleaning, and so on. But sort of as ever, the problem often isn't so much what a company does or doesn't do, it's whether they can prove what they have done. That's the issue when it comes to litigation. If a person alleges that you didn't have a good system in place, if a person alleges that the person that was cleaning wasn't properly trained or didn't have the right equipment, what evidence do you have to demonstrate that that isn't the case? So we will be looking for documentation, the risk assessment. Has it been regularly reviewed? Is it up to date? The method statement, evidence of the equipment that was provided, is that documented? What about training records? Can we prove that the cleaners were properly trained? So it's, not so much, not all did you do it, but can you prove it? That's what's so important from a legal perspective, and what's so important when you're trying to defend a claim. So that's the starting point, really. So we would, following an incident, we would have that kind of conversation with the company. We'd ask for lots and lots of documents, and hopefully we'd be able to build a defence on the basis of the documentation that we've received.
Yeah, and the sort of line in the sand, as it were, in terms of, are you liable as an occupier or as an employer or not, is on the balance of probabilities, if I'm correct. So in other words, if you're 51% on the right side, then you're okay, and if you're 49%, you're not. It's not like a criminal, a murder or something like that, where you have to be beyond all reasonable doubt or something like that.
Yes, yeah. That's right. I think the key concept is the one of reasonableness. That it doesn't have to be a perfect system. Things will happen in the real world to cause substances to get on the floor. And those substances won't be immediately addressed necessarily. What you need to show is that you have a system that is a reasonable one given the particular context, the footfall, the environment, and so on. So that will depend on the size of your business, the number of people in the premises, and so on and so forth. So it's not a counsel of perfection. It's a counsel of reasonableness. Can you demonstrate it's a reasonable and appropriate system? And when it comes to proving the claimant, you're right, has to prove that there was a failure on the balance of probabilities. So courts don't deal in sort of absolute science. They consider reams of evidence and have to ask themselves, am I satisfied that it's more likely than not that there was a failure here that led to the accident? So that's the approach that's taken.
Yeah. No, that's useful. It's useful just to confirm that, because I think people, as you say, people sometimes kind of forget that there's no expectation to eliminate accidents. There's no expectation to eliminate risk, and even where we've worked with clients and gone through huge processes and done loads of systems and everything, you can't expect to totally eliminate your accidents. But as you say, it's about, well, we've done this, we've done that, we can prove we've done it, we can prove we've done this, and that all sort of adds up and helps. When people are talking to their insurer about renewals and things like that, something that is really helpful is to sort of be able to provide some evidence to show that you're a good risk in the insurance world parlance. In other words, that you're better than average, let's say, and compared to your peers, and therefore the insurer has more confidence in being able to insure you. Does that kind of thing help? So if, let's say you're trying to defend a claim on behalf of a cleaning service provider, and you could show that something did happen in this case, clearly, otherwise it wouldn't have got that far. There was an accident, but actually, we the client, our average performance is, 5 accidents per 1,000 employees, whereas the industry standard is 15 accidents per 1,000 employees. Would that kind of thing be helpful?
Yeah, absolutely. The more risky you are as a proposition, the higher your premium is likely to be, and that's the sort of assessment that insurance companies will make. So being able to demonstrate that you have a good sort of claims history is going to be important, and ought to lead to lower premiums. Being able to demonstrate that you have a good system in place will reassure employers that insurers rather, that going forward you are a relatively safe proposition. So I think it's both your history and also evidence of suitable systems in place to reassure insurers that going forward you're an acceptable risk for them.
Yeah. So if we think about an average client, I know every client's different, but over your years of dealing with these kinds of slips and trips, in those areas that you've identified as being important, where would you say that people are typically strongest, and where would you say that people typically have kind of the most room for improvement?
Yeah, I think over the sort of decades, there's undoubtedly been a greater appreciation on the part of employers about the sort of importance of health and safety. So at a high level, you do see that, I think now quite comprehensive risk assessments, often particularly large operators, large employers, large service providers. You see reasonably good safe system of work documents, training records. That side of things, I think, is pretty well handled. Where it sometimes falls down is sort of breaks in the chain. So training records are lost. Risk assessments are not reviewed sufficiently regularly. They fall behind in terms of the technology. So the equipment may be out of date. There may be better cleaning equipment available, for example.
Yeah.
So I think at that level, the weaknesses can arise. And also, I think particularly in the sort of facilities management industry, there always has been historically quite a high turnover of staff. So investigating incidents can be quite hard because the individuals employed who were there at the time, they're gone. So unless you're quick, unless you're able to respond speedily following an incident, you may find that the evidence is lost. And I think there's a whole piece around speed of response, being able to investigate really quickly after something occurs, and being able to capture good evidence very early on. It's been a huge area of concern for me over many years, and trying to help companies to be much better at doing that. And it's so frustrating often when you have to advise a client that yes, I believe that you had a decent system in place, and I think your training was very good, but we're missing that there's crucial few hours. What was the floor really like at that time? Why weren't photographs taken? Yeah. Why didn't you speak to that lady who was there? So part of what I do is provide training to companies to be better at that, to help them to capture really good evidence that will be really useful should a claim arise subsequently.
Yeah, that makes perfect sense to me. And going back to something you said earlier about if you are a third-party cleaning or FM provider, there's sometimes that disconnect, isn't there, whereby the accident may occur, but then you're not sort of notified about it very quickly because the claim would typically go through to the building owner or manager rather than you. So yeah, that's a gap that probably needs to be addressed in some way, or try to address in some way.
I think that's such a big issue, actually, that an incident occurs at your client's premises, and at some point, it could be up to 3 years, of course. At some point after the incident, it's notified to the employer that was working there, or the main operating company at the site, and they may spend time investigating, and then eventually you get an email as a cleaning company or the maintenance company saying there's been a slip. We think it's down to you. You failed. You need to indemnify us. And you look at the contract, and the contract says we agree to indemnify you in relation to any trips, slips, and falls that arise from the provision of our services. And you're on the back foot. Who do you talk to? Everyone's gone. The area that you want to go and inspect has completely changed. It's very, very difficult. That perhaps your client doesn't really want to give you the papers they've got. They've done their own investigation, but they're reluctant to pass those documents on to you. So I think it is so important to ensure that you do have, so far as possible, in place good protocols between you and your client for notification of incidents. So we're agreeing to pick up and deal with a certain type of claim, but that means you need to tell us about it. We need to be able to investigate it properly, and that can be a real area of friction. It can generate lots of legal costs that might eventually be passed down to the ultimate service provider, and it can be a problem. So something to be addressed, I think, and thought about carefully.
Yeah, I've got a bit of a passion about trying to solve this problem in some way, because I see that we support many service providers as you do, and they're under very tight margins because it's a very competitive industry, and so any single claim could knock out the value of an annual contract very, very easily. So I think trying to be a bit more creative and a bit more proactive around what they can do is something that I'm sort of certainly recommending. So for example, before you take over a building, why not just spend that bit of extra time and do a bit of a robust assessment of that particular building, because you know, you could be being given a hospital pass, to use a sporting terminology, where actually, you know, there's, I don't know, an office building with, you know, very shallow entrance matting and a very shiny floor, and it's going to be impossible to keep that floor dry consistently throughout the day. And therefore, why should you be indemnifying? That's the built environment, it's not under your control, so why should you be indemnifying your client if someone slips in that scenario?
I think that's a brilliant idea, and such a simple one, and one of those things you think, yes, of course, when you hear it. If you're taking on the responsibility for cleaning premises, you really need to know what the condition of the floor is, and carrying out early tests to know might lead to further with the clients about, you know, how many people we think we're going to need to employ on this contract, you know, the price of the contract as a consequence, or areas that we think need to be addressed. So important, and I guess that's where you can come in, helping companies to do that.
Yeah, definitely. A few quick things on slips and falls there, and then we'll move on to some of this COVID stuff. If I think about clients or buildings, clients that I see or buildings that I visit, and I think of control measures where people are trying to protect themselves either from preventing an accident and or but sort of being in a position to defend a claim. The typical things that I see are, you know, cleaning check sheets or inspection sheets and yellow signs. I wondered if you could just speak to the kind of the value of those, and, you know, whether they are helpful or not, or they are helpful in certain circumstances or not, for example.
No, they are helpful. If you need to prove that you were cleaning in a certain area at a certain time, then clearly you need some sort of record of that. You need to retain that record. It also goes to the sort of adequacy of your system overall. So, you know, how frequently did you visit certain areas? Logging that is extremely useful. But otherwise, it's just, you know, one word against another about what was actually done on the day, or as a matter of course. And I would have thought that we ought to be moving beyond, you know, retaining paper documents to using all of the sort of technology that's literally at our fingertips to be able to record and log what we are doing. So it shouldn't be a hugely, I would have thought, arduous process. The technology is there. You can capture what you're doing. You can take photographs. You can, you know, do lots of things very easily to record your system, record evidence of what you've done.
Yeah. And what about signage? So to me, I'll give you my view, and then you can tell me I'm wrong probably. But I think there are two scenarios where signage is used. One is when people are cleaning, whether that's you know, the routine cleaning, or whether they're dealing with a spillage, and they put a sign up and it says cleaning in progress, be aware. And the other scenario is where people just put a sign out and kind of expect that that will help them to you know, not be liable if somebody slips and falls. So, for example, you know, one of the big exhibition centres in London, they have signs in the washroom saying "caution, floor slippery when wet," or something, words to that effect. And I just think to myself, well, that's not very good, because if you know that the floor's slippery when wet and you're in a washroom where the floor is going to get wet, I don't think that's particularly helpful for you to be, you know, in a position to defend the claim. If anything, I'd have thought that, you know there's a problem, you're not really addressing it, and that's going to be more problematic than beneficial.
I'm not going to disagree with you, Christian. I think that's absolutely right. And when signage is important, when you are carrying out a cleaning operation, anyone approaching that area needs to be put on notice that that's what's happening, that the floor won't be bone dry. Hopefully the cleaner will be trained to ensure it's as dry as it possibly can be as they go through the cleaning process, but it's going to be to some extent wet. So signage is really important, but it's as important, I think, to remove the signage when the operation's over, when the floor's dry. Leaving signs out just routinely is introducing a tripping hazard.
Mhm.
It's not warning of a floor that may be slippery, and it also makes people ignore them. So
Yeah.
if you're working in an environment where you know the signs are routinely left out, you will just pay less and less attention to them. It's not warning you of anything. It's just, oh, there's that sign that's always there. It
Mm.
tells me nothing really of use. So I would agree with you. They
Yeah.
need to be used appropriately.
Yeah. Okay. No, that's good. And then lastly on slips and trips, then we've been working together on a few bits and bobs, and one of those was a case where a lady, a sort of aqua aerobics instructor, slipped on a poolside, and so part of that was quite a serious incident, and we came in, or I came in myself, should I say, and did some slip testing as part of that. And I just wondered if you could comment on what you sort of perceive from a sort of defensibility perspective, the value of having slip testing data sort of proactively, and then also, what the reality is in terms of, if you're getting to that point where you've got a quite serious claim and there is some slip testing evidence, where that sits in terms of ranking of importance and the outcome of that, if it's a good result versus a bad result.
I think it can be very useful. Of course, when you're carrying out the slip test, you are you are assessing the quality of the slip resistance at a point in time, and that may be clearly sometime after the incident occurred. So it doesn't tell you necessarily what the condition was like at the time of the incident, but it could very well be a good indication of what it was like. In fact, it may be possible to say that it's safe now, so it must have been safe in inverted commas at the time of the incident. So it must have had an adequate level of slip resistance at the time of the incident. So I think it is valuable, but equally importantly, to have a program of sort of periodically checking prior to incidents, so that as part of your health and safety risk management program, you are periodically checking from the point you become engaged with the premises, but at certain junctures subsequently. I think that would be useful. I'd be interested in your thoughts, Christian, about how perhaps frequently you think an operator ought to do that.
I would say it's going to vary depending on the sector and the area of the building. So I always say to people that I'm only really interested in perhaps 5% of floor surfaces, because the vast majority of floors are not foreseeably wet or contaminated, and therefore actually doing a slip test is not really going to add much value in that scenario. There it's all about, as you say, getting the right control measures in place in terms of cleaning, and then principally about how you can deal with spillages or any kind of unforeseen contamination as quickly and sort of robustly as possible. Whereas the example of the poolside or a building entrance or a kitchen or a hotel bathroom or a sort of an external area, obviously, because it's going to get wet if it's external, certainly in the UK. I would say probably annually would be a good frequency. I think anything more than that is probably overkill, unless you've got sort of a particularly high risk for whatever reason. But we would typically say to clients, get some testing done from a proactive perspective, act upon the results, because that's really important. Because obviously, if you go and test and it's in an area that is likely to be wet or contaminated and the results are not as good as you would hope for, and then you don't do anything about that, that's difficult, obviously, because you kind of know there's a risk. So get the testing done, act on it, and then sort of monitor it kind of annually, I think is reasonable. I think anything more than that would be difficult. But equally, if you leave it too much longer than that, as you said, you're measuring a point in time. So if you've got a test from 5 years ago, I don't think you could really rely on that being an accurate description of what's happened on the day of an accident 5 years in the future. Does that sound sort of reasonable?
Yeah, that does sort of sound, it sort of chimes with what I would hope to see, and it would be useful to have that. As it's not clearly isn't the be all and end all, but it's one piece of the jigsaw. when it comes to managing risk and being able to prove that you've discharged your duty of care as an occupier or as an employer.
Yeah, definitely. Yeah, it's something I've I've been calling for, and some of the insurers are on board with that concept and they're recommending it, and it feels like we're making some good progress. So yeah, fingers crossed that will continue. Great. Well, we've done good justice to that. So let's move on to just a small trifling issue of something called COVID. I don't know if you've heard of it, but
something on the news recently.
Yeah, a few people think it's important. So if we wind back sort of 18 months ago, there was kind of a lot of, I think, worry from insurers, certainly, that there was going to be this kind of tsunami of claims where, I went to your restaurant or I work in your factory and I've got COVID and it's your fault and I'm going to put in a claim against you, and what would that look like? It doesn't feel to me like that's happened, but what's your sense of that?
No, I think that's right. I mean, there haven't been many claims, and when one thinks, well, why is that? The obvious answer, I think, is it's extremely difficult to prove that your disease came from this entity, this employer, this restaurant's breach of duty. COVID is everywhere. It's out there. It's on the bus you travel to work on. It's in your home. It's in your school. It's everywhere. So being able to prove that this was the source is always going to be extremely difficult. My view is that sort of public liability claims against restaurants and pubs and so on would be sort of almost impossible to prove. There may be exceptions, but almost impossible. The more fruitful area will be within workplaces, particularly sort of confined areas where there are a cluster of incidents that are proximate in time and space. So several people in quick succession developing the disease. Back to balance of probabilities, it becomes a lot easier to persuade a court that your infection and subsequent disease was caused by the workplace environment than some other cause, if that's what you're looking at. So I think that we will see claims, but they will tend to be restricted to that sort of employer-employee environment.
Yeah.
Or of course, areas like care homes, prisons, those kinds of confined areas where it's easy to prove on the balance of probabilities. But I think that the bigger concern for employers, for insurers, will be sort of ancillary claims that arise from the pandemic. So your workforce is reduced because people are isolating. Is there overstretch with those that are left behind? Are they taking on too much? Are they using equipment they're not properly trained to use? Are they becoming stressed to a level they can't cope with, leading to psychiatric conditions because they're overworked? So those, I think, are potentially more problematic areas. And then there's a whole sort of work from home piece as well. We know that the employer's duty of care doesn't end at the boundary of the workplace. If you're requiring or allowing people to work from home, you still owe those employees a duty of care. Quite how you discharge that duty will differ if they're in their own home environment, and will be potentially more challenging. But they're still owed a duty of care. So one can imagine, for example, musculoskeletal injury because home workplace is not properly set up. Again, mental health issues. We know that is clearly an issue with people feeling isolated and stressed, perhaps worried about money, perhaps family members who have been made redundant. All of those are elements that can feed into sort of mental health challenges. So if you're not cognizant of that as an employer, or if you're not putting in place systems to mitigate that risk, then you potentially would be in breach of duty and could be subject to a claim. So I think those are the areas that one might begin to see claims coming through on.
Yeah. Do you think that there'll be a difference in if a company has a formalized stance about working from home versus sort of so far everyone's gone and worked home because that's the reality of what we had to do? But if people then sort of formalize that and say, right, we're closing our offices, you are working from home full time, versus the kind of a more relaxed sort of hybrid method, do you think that might have a sort of a line in the sand where if you cross that, then it's going to be more important to follow through on that duty?
That's a good question. I don't think so. And sort of formalising things in that way might bring its own sort of challenges, its own difficulties. I think what's important is to properly think through these issues, to sit down and just reflect on what your people do, and what risks arise from that, and keep reviewing that. I mean, that's crucially important. So with the pandemic, what we've experienced over the last 18 months or so has been a developing picture. It's constantly in flux. The government guidance has changed to reflect that. The regulations came in and then they went. So we're living in a fluid environment, which is a challenge for employers. But what that means is you need to rise to it. You need to regularly review your assessment, and you've got to communicate that. And the law is very clear about this. You prepare the risk assessment and you communicate that to your staff. You help them to understand what measures you have taken to make sure they're safe, doing their work, whether it's at home or in the workplace.
Yeah. And what about the opposite of that? So I've got friends who work for companies who have sort of said, we're now working from home for the foreseeable future. And then I've got other friends who work for companies who've been very militant almost on, we want everyone back in the office. And obviously that brings another sort of opposing set of risks, doesn't it, I suppose?
Yeah. Oh, it's such a hot area at the moment of sort of debate and discussion. It comes back to the duty of care. Is it consistent with your duty of care to require all of your staff to be in the office? Well, it might be. Does your office have very good ventilation? Can you demonstrate that? Can you ensure people are properly spaced? Do you have adequate controls in terms of hygiene? Other sort of infection transmission mechanisms. If you are operating well in those areas, then it might be entirely consistent with your duty of care to say that we're now going back to the office, workplace, whatever it may be. If you're just telling people to come back, giving no thought to those things, then you are, you're asking for trouble, really. That doesn't seem to me to be the actions of an employer taking reasonable care for the health and safety of employees. Yeah. I do have a sort of a bit of a concern that sort of Freedom Day, 19th of July, came around, and you get the sense that some employers concluded that means we go back to pre-pandemic days, that everything returns to normal. But it's not normal. It isn't normal at the moment. Infection levels are very, very high still out there. So I do think it's important for employers to just keep this at the forefront of their mind. And there are some things that can be done relatively easily and are inexpensive, so they're reasonable to do. And we know what those things are. Ventilation, I think, is a big issue. I think the real need for employers to think seriously about the quality of the ventilation, and there are standards out there they need to be familiar with when it comes to air recycling and so on.
Yeah, and that's something that has obviously developed. As you said, it's a quite fluid situation, and the understanding of the ventilation aspect has developed a lot, hasn't it? So if you compare when it first started, it was wash your hands and it was
all about surfaces and contact.
Yeah, and surfaces and contact, and obviously that still remains a risk, but I think it's a relatively low risk compared to the surface transmission, and therefore getting the ventilation right. And but of course, there have been many companies who haven't closed down at all. They've had to carry on, and that must be very challenging, because you're having to do this in a very dynamic way and make quick changes without the opportunity to sort of take a step back and think, okay, well, we're not opening for another month, so we've got a bit of time to think about this. Yeah,
no, really challenging for those businesses that provided essential services that had to continue to do so throughout the early days and onwards of the pandemic. So particularly challenging for them. But I think, again, you're back to, it's not a counsel of absolute perfection. Different employers may reach different conclusions about what they should do, and both of those may be reasonable conclusions. I think that's the important thing. You know, show you're working, show that you thought about it and you reached a conclusion about what we ought to do to make sure that our staff are safe. That's the critical thing.
Yeah. Thinking about COVID specifically, and any claims that, you know, if they were able to be proven on the balance of probabilities, I would imagine that the biggest potential exposure would be if we had a sort of a long you know, maybe a cluster of, you know, 3 or 4 people who worked together in a kitchen or something, who all developed long COVID. I mean, that have you got any idea of what that could look like in terms of, you know, the potential cost of that kind of thing, as a way just to sort of bring it to mind for people to think, oh, actually, yeah, we should consider this because it might be very expensive.
Long COVID is really interesting. It's a non-clinical term. It's referring to those who have ongoing symptoms following a period of COVID-19 disease, or develop other symptoms in the aftermath of the acute period. And we do know, there's lots of things we don't know, but we do know there seems to be quite a sizable proportion of those who contract the disease who complain about ongoing symptoms for, you know, potentially many months or longer, or continuing to complain now of symptoms following COVID-19 disease. And some of those symptoms can be very debilitating. Fatigue is very common, which in itself can be, it's not just being tired, as we know, it's you're exhausted. You cannot do what you used to be able to do. Yeah. Breathlessness. This virus can damage the lungs, cause fibrosis of the lungs, and that can lead to breathlessness, which would make certain activities more difficult. Heart issues. It is fascinating how it appears the virus can provoke responses in lots of the body's systems and organs that are damaging. You know, cognitive impairment. And I was talking to a scientist who specialises in the treatment of long COVID a couple of weeks ago, and she was saying it is extraordinary. One of the tests they give is they will ask the sufferer to tell them as many words as they can beginning with F, and one of these patients was formerly an executive, very high-powered job, leading a very large team, and all he could think about was the word football. That was the only word he could say, and it was deeply frustrating to him. But you know, something has changed following his period of COVID-19 disease. Now that chap, unless he recovers, will not be able to go back to doing the job he did before. No. And we may find that even if the the proportion of those who develop the disease go on to develop long COVID is small, if lots of people have the disease, that could still be a sizable number. Yeah. And that's going to pose real challenges for employers, I think, in terms of managing those people as they return to the workplace and making reasonable adjustments for them where necessary. And you asked about, you know, potential value of claims. That really is how long is a piece of string, because those symptoms may resolve quite quickly, or from our perspective here, at still the early stages of understanding this condition, they may affect someone's life for the rest of their life. Yeah,
and that's where claims become expensive, isn't it? So, you know, just returning to slips and falls. You know, I've acted on a few death cases as like an expert witness, and actually the quantum of a civil claim for a death is relatively modest, versus somebody who were paralysed, let's say, and needed you know, care for the rest of their lives. You know, that's a much more expensive claim, isn't it?
Absolutely, that's right. And if you are potentially a long COVID sufferer, may be classified as disabled, substantial impact on their day-to-day activities and ability to work, and symptoms lasting for more than 12 months, you're beginning to potentially fall into this disabled category, which has big implications for the calculation of your loss of earnings even if you return to work, because the way that future loss of earnings is calculated, your potential earnings as a disabled person are thought to be significantly lower over the course of your working life. So that might generate quite significant future loss of earnings claims. But no, you're absolutely right. It's an area that we need to keep a beady eye on. And I'm hosting a webinar in October, date yet to be confirmed, in which I'm bringing a couple of scientists who are genuine specialists in this area to talk about what we know, what we don't know, what's unclear, what is becoming clearer. I'll be addressing the subject from my perspective as a personal injury lawyer, and a colleague who's an employment lawyer will be talking about an employer's responsibilities and how you manage that from an employment law perspective. So I think that'll be an interesting session.
Absolutely, yes. And you beat me to it, because I was going to do the segue into talking about your webinar, but you got there before me. So very, very well done for that. Great discussion, really, really valuable. I think people have learnt a lot and have a lot to take away and go and think about, which I guess is the point. So is there anything else, just drawing things to a close, Greg, that people could go and do, other than maybe follow you on LinkedIn or connect on LinkedIn and attend that webinar? Is it any other resources, or you're happy for people to reach out to you to chat directly?
I'd be delighted if people linked in to me, and I will certainly be posting links to the webinar coming up, and any of the webinars we'll be doing through my personal LinkedIn account. Follow CMS. CMS doing lots and lots out there in terms of helping clients in our new environment. So yeah, follow CMS, follow me, and I'd be delighted for as many people as possible to attend the webinar when it comes up.
I'll give that a plug when you've got a date as well, and on my LinkedIn, because it's a topic that I'm interested in too. So yeah, certainly be happy to help out there. Great. Well, thank you very much, Greg. Really enjoyed it, and thanks everybody for joining us as well. I hope you found this useful. If you did, please hit follow or subscribe, or whatever the word is now on the podcasting platforms. Please give us a review as well. That's always interesting and useful, because it helps more people to learn about the show. And we'll look forward to seeing you again next week.